Ladies and gentlemen, today's courtroom showdown is one of those hearings that starts as a simple trespassing case and then spirals into absolute chaos. What should have been a straightforward arraignment for a petty trespass charge quickly turns into a bizarre constitutional debate, a battle over jurisdiction, and eventually a full-blown competency concern raised by the judge herself. Now here's what makes this case so fascinating. The defendant, Kenneth Failen, walks into court convinced that the entire system has no authority over him. He repeatedly insists he's appearing under special appearance, claims the Constitution protects him from prosecution, questions the court's jurisdiction, and refuses to answer even the most basic legal questions directly. And if you've watched sovereign citizen-style arguments before, you already know where this is headed, but this judge handles it in a way that is calm, methodical, and honestly pretty masterful. What starts as the judge simply trying to explain a trespassing charge slowly turns into a courtroom chess match. Every time the judge asks a yes or no question, the defendant responds with vague constitutional phrases, circular arguments, or statements that don't actually answer the question. But instead of losing control of the courtroom, the judge keeps pulling the conversation back to reality and forcing the process forward step by step. And then comes the turning point. The moment the judge realizes this may not just be someone refusing to cooperate, she begins questioning whether the defendant is actually capable of understanding the proceedings at all. That changes everything, because once competency becomes an issue, the court is legally required to stop and investigate whether the defendant can meaningfully participate in his own defense. So now the entire hearing shifts from, "Are you guilty or not guilty?" to "Are you even competent to stand trial?" Pay close attention to how the judge explains the law here, because this hearing becomes a perfect example of the difference between internet legal theories and actual courtroom procedure. And trust me, once the defendant starts refusing to provide contact information, claiming his address is private property, and walking out without signing the protection order, things get even more unbelievable. And while you're watching this unfold, let me ask you this. Do you think this defendant genuinely misunderstands the legal system? Or do you think he's intentionally trying to avoid the court's authority? Drop your thoughts in the comments because this one is going to divide people fast.
I'll find good cause, or I don't need to find good cause. Mr. Failen, did you understand the rights that you have that I explained earlier?
I'm here under a threatened arrest from the state of Colorado, and I retain all of my rights.
Okay, so I'm assuming since you're retaining your rights that you understand what your rights are, correct? All right. In your case, you're charged with a petty offense of third degree petty offense. A petty offense of third degree trespass. If you were to plead guilty or be found guilty of this offense, you could be ordered to serve up to 10 days in jail and pay a fine of up to $300. Do you understand the charge that you are accused of?
No.
What about that charge do you not understand?
To the U.S. Constitution, I'm allowed to go into, well, I have a right to petition the government, and so I don't understand how this charge is lawful.
Okay, well, you're accused of this. Nobody's finding you guilty. If you believe that you have a legal defense, you can say that you're not guilty and request a trial and require that the prosecution prove the charge beyond a reasonable doubt before you could be convicted or found guilty. But right now, I'm just telling you what you're accused of. Do you understand what you're accused of?
Not guilty.
Okay. That's not, you're moving steps ahead before my question is, do you understand what you're accused of?
No.
What about the accusation do you not understand? I understand that you think you're not guilty, but in order to think you're not guilty, you have to understand the accusation. By saying that you're not guilty, that implies that you understand what you're accused of, because you couldn't say that you're not guilty if you didn't understand it. So do you understand what you're accused of?
I am in standing of being that this charge is frivolous.
This
and
right here is where the hearing completely shifts from confusion into full-blown sovereign citizen territory. The defendant is trying to argue that the state court somehow lacks authority over him because he's a person of the United States and believes only the Supreme Court has jurisdiction. But that's not how constitutional law works at all. The judge immediately recognizes what's happening and doesn't let the courtroom get dragged into nonsense arguments. Instead, she keeps redirecting him back to the actual legal process. And honestly, that's important because courts deal with this kind of argument more often than people realize. The internet is full of videos and forums convincing people they can magically escape criminal charges by saying certain phrases like special appearance, I retain my rights, or I do not consent. But courts don't operate on YouTube logic. They operate on statutes, procedure, and jurisdiction established by law. What's really interesting here is how patient the judge remains. She isn't yelling, threatening, or mocking him. She's trying to walk him through the process step by step while also preserving the record. And that matters because appellate courts later review whether a defendant was properly advised of their rights. But let's be real for a second. If someone can't clearly explain their argument, can't answer direct questions, and keeps jumping into unrelated constitutional buzzwords, that raises a huge red flag inside a courtroom. And we're about to see that concern become the central issue of this hearing. So what do you think? Should judges shut these arguments down immediately, or is it important for them to give defendants room to explain themselves on the record? Because this judge is walking a very careful line right now.
And so the the jurisdiction is led to the Supreme Court
So
I do not.
You're
know
not
that-
making
I
sense.
don't think
The
that
court
there's any
has
witnesses.
jurisdiction.
I don't believe there's any witnesses, or can we?
You might think that there's no witnesses, and there might be no witnesses, but if there are, you can't harass, molest, intimidate, or retaliate against them.
And
Okay.
can we set a date for discovery or?
So if you need information about how to get the discovery in the case, you would need to contact the office of the district attorney. I don't have any discovery in the case. I have no police reports. I don't get any of that. If you want any of that information, you have to get it from the district attorney's office. I believe that they have a form that you have to fill out that tells them where you want them to send that information, and then they'll send it to you. Okay? So right now, you can't harass, molest, intimidate, retaliate against, or tamper with any witness or victim of the acts that you're alleged to have committed. This is a condition of your bond, and if you were to be suspected of violating this order, you could face additional criminal charges. So in a moment, my clerk's going to have a copy of that protection order. She's going to ask you to sign it and acknowledge that we're giving you a copy of it. And you can take a copy of it with you. If you have questions about what that order says, you will have a copy and you can read it as many times as you want to, or go over it with the help of an attorney, okay? So in a moment, my clerk will give you that. In this case, you have the right to have the help of an attorney. Are you planning on hiring an attorney or applying at the public defender to see if you qualify for a free attorney?
I am I'm appearing as a special appearance today, and
You're not appearing as a special appearance. You're appearing as Kenneth Failen here standing in front of me in the courtroom. A special appearance is when you're an attorney.
Kenneth Failen.
Mr. Failen, if you want me to find that you're not Mr. Failen, then I'll issue a warrant for your arrest for failing to appear. Do you want me to do that?
Well, that's what happened last time, but I don't.
Last time you didn't appear in court, so I issued a warrant for your arrest. So if you want me to make a finding that you're not stating that you're Kenneth Failen, then I'll find that you failed to appear and I'll issue another warrant for failing to appear. So.
No,
I'm going to,
And
Don't do
there it
that.
is. The exact moment the judge's concern shifts from frustration to competency. Up until now, this could have been interpreted as someone intentionally being difficult or trying to use pseudo-legal arguments to derail the proceedings. But when the defendant suddenly struggles to answer basic questions about what an attorney even does, the judge's tone changes completely. This is actually a major legal turning point. Competency is not about whether someone is intelligent, agrees with the law, or even behaves respectfully in court. The legal standard is whether the defendant can understand the proceedings and assist in their own defense. And once a judge genuinely questions that, they have an obligation to act. Notice how carefully the judge explains the process. She's not declaring him guilty, crazy, or incompetent on the spot. She's saying there needs to be a professional evaluation by a trained doctor. That's a huge distinction a lot of people misunderstand online. The competency process exists to protect the defendant's constitutional rights, not violate them. Ironically, the defendant keeps insisting the court is harming his rights, while the judge is literally slowing everything down to make sure his rights are protected. And from a legal perspective, if the judge ignored these warning signs and pushed forward anyway, the entire case could later get overturned on appeal. Also, can we talk about how fast this escalated? We went from a petty trespassing charge with a maximum of 10 days in jail to a competency evaluation discussion in under 20 minutes. That is an absolutely wild courtroom spiral.
I mean, I'm being present in court. It's the state has like
it's a yes or no question. You told me that you were
Do I-
exercising all your rights. One of your rights is the right to have an attorney. Do you understand that? Yes or no?
no.
What don't you understand about your right to have an attorney?
How I so why this charge has has like brought me it's what do I so an attorney has to be, so if I want an attorney, then there's somebody else in the case that like it would be
Today?
nope.
It appears to me that you are having difficulty formulating thoughts or expressing yourself in complete sentences. I'm concerned about your competency. So at this time, I am going to raise competency for Mr. Failen. When a court raises competency because they are concerned that you are not competent in this case, that means that I believe that you're suffering from some sort of impairment of thought that allows you to understand these proceedings and participate in the proceedings. So the state of Colorado has to have an evaluation done of you by a doctor who is trained in impairments of the mental condition. And then that doctor conducts an evaluation and writes a report and tells the court what their medical opinion is of whether or not you are competent to proceed. So I'm going to issue an order that
I do not consent.
it's not something that you consent to. When I think that somebody's not competent,
So you give a
I am-
doctor a voice, not a person.
when I think that somebody is not competent, I am legally required to order a competency evaluation or make a finding that they're not competent and order that they participate in proceedings related to restoration to competency. It's not something I have a choice over. It's something that I'm legally required to do. And based on your
The damages that you have caused me.
inability to formulate complete sentences or express.
This court has caused extreme damage for the past 2 years. I'm here under threat and duress. So that's all I have to say.
All right, so I am raising competency with regard to Mr. Failen. My clerk of
At
court
this point, the judge is practically begging the defendant to cooperate enough for the process to move forward smoothly. But instead, every answer creates a new problem. Refusing to use a phone number, refusing to provide an address, insisting people can only meet him on private property. None of that helps his situation. In fact, from the court's perspective, it reinforces the exact concerns that triggered the competency evaluation in the first place. And here's the key thing viewers need to understand. Competency evaluations are not optional when legally ordered. Once the judge raises competency concerns, the court has to pause and determine whether the defendant can meaningfully participate in the case. That's why the judge keeps explaining she doesn't have discretion here. This isn't personal, it's procedural. What's fascinating is how the judge balances firmness with restraint. She doesn't instantly revoke bond, she doesn't throw him in jail for contempt, and she keeps giving him opportunities to cooperate. She even arranges for the Bridges Court liaison to meet him directly and help coordinate the evaluation process. That's actually a much more measured response than many judges would have taken under these circumstances. But the bigger issue here is that the defendant seems convinced the court process itself is illegitimate, while the court is focused entirely on making sure the process is legally valid. And those two realities are completely colliding in real time. So let me ask you this. At what point should a judge stop trying to explain things and simply enforce compliance? Because some people watching this are going to think the judge was incredibly patient, while others are going to say this hearing went on way too long.
Failen, it looks like the summons lists an address on State Highway 131. I'm going to have you return to court.
I move.
Okay, I'm going to have you return to court on Friday morning, and I'm going to have the Bridges Court liaison here so that the Bridges Court liaison can speak to you directly about making an appointment with you. So I'll ask that you please appear on March 27th. That's this coming Friday at 9 o'clock in the morning. You can appear virtually or in person. I'll have the Bridges Court liaison here, and the Bridges Court liaison will talk to you directly about setting up a time to get in touch with you and meet with you, and setting up the evaluation. Okay?
And that's how this hearing ends. Not with a resolution to the trespassing case, but with the defendant walking out of court after refusing to sign the mandatory protection order and being formally ordered into the competency evaluation process. Legally speaking, the judge made several important rulings here. First, she ensured the defendant was advised of the charge and his constitutional rights. Second, she entered the mandatory protection order required under Colorado law. And most importantly, once competency concerns became clear, she followed legal procedure by ordering a mental health evaluation and appointing a Bridges Court liaison to coordinate the process moving forward. What makes this hearing so compelling is that the judge never really argued emotionally with the defendant. She repeatedly brought the discussion back to procedure, legal standards, and the defendant's ability to understand the proceedings. Whether you agree with the defendant or not, this was a textbook example of how courts balance constitutional rights with concerns about competency and courtroom order. Now, the next major question is what happens after the evaluation. If doctors determine he's competent, the case moves forward toward trial. If not, the court could order treatment or competency restoration proceedings before the criminal case can continue. And honestly, this entire hearing is a reminder that internet legal theories can collide very hard with real courtroom procedure. Saying phrases like special appearance or I retain all rights might sound powerful online, but in an actual courtroom, judges are looking for legally relevant answers and coherent participation. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.